Pastor Vince with Clergy in Support of the Second Amendment, coming to you with breaking news today. As you may have heard, the Supreme Court has handed down an absolutely epic decision in the New York State Kerry case. Really, they've handed us a three-part victory, and I want to talk about those three parts in this video. The first victory that is handed to us, the Supreme Court has handed to us, is an affirmation of the right to carry a firearm for self-defense outside the home. Let me read from the decision. Justice Thomas, absolutely brilliant. The constitutional right to bear arms in public for self-defense is not a second-class right subject to an entirely different body of rules other than the Bill of Rights guarantees. We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need. That is not how the First Amendment works when it comes to unpopular speech or the free exercise of religion. By the way, that's why my whole channel exists and all of my social media outlets. There is a direct link between freedom of religion and the Second Amendment. It is not how the Sixth Amendment works when it comes to a defendant's right to confront witnesses against him. And it is not how the Second Amendment works when it comes to public carry for self-defense. Goes on. New York's proper cause requirement violates the 14th Amendment in that it prevents law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms. We therefore reverse the judgment of the Court of Appeals and remand the case for further proceedings consistent with this opinion. Let me tell you what that means. As of today, effectively, we have nationwide shall issue. It may take a few weeks for it to get into effect, but if they're smart, all of the states will now revise their laws and policies and simply go to nationwide shall issue. California, New York, Hawaii, etc. Now, there's been a lot of talk about how New York was going to try and get around this. And one of the really most popular ways they were going to get around it was to declare all sorts of places to be sensitive where they could ban carry. Well, that came up in the oral arguments, and Justice Thomas and the 6 justices in the majority directly addressed that. And they severely restricted sensitive places. It's going to be strictly according to current precedent. I'll read from the decision again. Consider, for example, Heller's decision of long-standing laws forbidding the carrying of firearms in sensitive places such as schools and government buildings. Although historical record yields relatively few 18th and 19th century sensitive places where weapons were altogether prohibited, such as legislative assemblies, polling places, and courthouses, we are also aware of no disputes regarding the lawfulness of such prohibitions. So they've listed the places that precedent says you can prohibit carry. Schools, government buildings, legislative assemblies, polling places, courthouses, and they go on. Courts can use use analogies to those historical regulations of sensitive places to determine the modern regulations prohibiting the carry of firearms in new and analogous sensitive places that are constitutionally permissible. In other words, it's got to be broadly similar to the places listed. They can't just declare any place with more than 20 people a sensitive place. The justices have taken that off the table. They can't declare any place where there's a lot of people a sensitive place and prohibit carry. That was their first plan. They were going to prohibit carry basically everywhere. That's off the table. It's gone. So what they're going to do, I don't know. They'll try something. But I predict right now the court's going to swat them down. So the first thing we got affirmation of the right to carry. Second Amendment, it sends outside the home. Second thing we got, you can't use sensitive places to virtually ban carry. There's only a few places you can ban carry. And last of all, and this is the most important part of the ruling, the justices have ruled that the reasoning process used by lower courts to uphold assault weapons bans, magazine bans, and a host of other laws is unconstitutional. Let me explain what they do. They use a two-step process, and this is what has been used by the Ninth Circuit. It's what's been used by almost every other court. If you've heard of a case where an assault weapons ban has been upheld, they've used this reasoning. It goes like this. Well, yeah, this law violates the Second Amendment. It restricts the Second Amendment right. We know that. But we're going to use intermediate scrutiny. And we're going to balance the rights of gun owners against the rights of the rest of the public to be safe. So this law is constitutional. For instance, the Ninth Circuit. Well, you know, you can have a 10-round magazine, so the fact that larger magazines are in common use, we're going to just say those can be restricted because you can still have 10 rounds. And you still have some way. So we're going to balance your rights against what we think the restrictions should be. Listen to what the High Court said about that. Since Heller and McDonald, the courts of appeals have developed a two-step framework for analyzing Second Amendment challenges that combines history with means and scrutiny. The court rejects that two-part approach as having one step too many. Step one is broadly consistent with Heller, which demands a test rooted in the Second Amendment's text as informed by history. But Heller and McDonald do not support a second step that applies means and scrutiny in the Second Amendment context. That's right. It'll take a while. Maybe not as long as we think, because there are cases right now involving magazine bans and also involving assault weapons bans that are on hold, waiting to see what the Supreme Court did here. Because they thought, well, if they rule on what our reasoning process is, it might affect how we rule. Well, it's gonna. It's gonna. I'll predict right now that the cases for assault weapons bans and magazine limits will definitely be struck down. And I would predict right now that if the lower courts persist in using this test, the Supreme Court will summarily reverse them. They have been crystal clear on this point. Additionally, by this test, most restrictive gun laws fail. If it infringes on the Second Amendment and there is no historical precedent for it, in the first couple of 100 years, they can't do it. This is devastating for gun control in this country. Absolutely devastating. We could not have expected more from this court. They have given us everything we really expected and hoped for. So that's what I have for you today. It's really nice to come to you with good news. Please consider commenting, subscribing, help to boost the channel. We're trying to get it off the ground. Need your help. God bless. Have a wonderful day.